This is the lowest.
All rise, please. Circuit Court is now in session. The Honorable Terrence Petrel presiding. Please be seated.
Hey, good morning. We're here on our miscellaneous criminal day. We will we'll begin with our from the private counsel, Mr. Kilpatrick.
Good morning, Your Honor. Keith Kilpatrick.
Hold on, let me find your case, please.
Yes, sir. Yes, sir. It's going to be Sean Thomas Foy, F-O-Y,
Got it.
and he is present in the courtroom as he approaches the lectern. I have a plea agreement to tender to the court. May I approach?
You may.
Your Honor, I'm just going to announce that this is just for your ability to follow.
Thank you.
Your Honor, Mr. Foy is before this court in case number 22 CF 2445. He's been charged with 1 count felony battery by strangulation. He's asked me to withdraw his previously entered plea, tender a no contest plea to a lesser included offense of misdemeanor battery. The agreement with the state is to put him in the pretrial intervention program where upon successful completion of the batter's intervention course, he will be successfully terminated off that program, and the state will withdraw his plea and dismiss his case. And that's all reflected in the agreement.
Let me just clarify. The way you're stating it is that if he completes the batter's intervention, is that the only?
That is the requirement, Your Honor.
That's the only requirement of the pretrial intervention?
Yes.
Yes, sir.
Okay. Okay, very good. Okay, Mr. Foy, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state you wish to enter the pretrial intervention program. What he didn't say is that if you fail to do this, that you have essentially you're pleading no contest, and you would be returned to the court for sentencing. Do you understand that?
Yes, sir.
Okay. In other words, we wouldn't kind of go back to square one on it.
Yes, sir.
You understand that? You've had all this explained to you by your attorney, gone over this from a legal standpoint, how it affects you legally?
Yes, sir.
Okay. And based upon that, the court will accept the plea agreement and will accept the lesser included charge of misdemeanor battery. There'll be a withhold of adjudication and pretrial intervention with automatic termination upon completion of the batter's intervention program.
Thank you very much, Your Honor.
Thank you.
May I approach and receive that gift?
You got to get back to them, that's right.
Yes, sir.
Thank you.
Thank you very much.
Thank you.
Good morning to you.
Yes, sir.
It is-
Currently, it's a withhold.
You weren't controlling for the freeway or? Since I can't take it today.
Your Honor, if you want to set, if Mr. Kilpatrick is fine for your next pretrial date, I'm sure we'll have everything closed out for that.
That would be fine with the defense.
Okay.
Thank you, Madam Clerk.
Thank you.
Thank you, Judge.
410. Thank you. Ms. Reed?
Good morning, Your Honor.
Good morning.
I have Mr. Jerome Tybell Hatton. He has 2 cases on this morning's docket. 19 CF.
Hold on a second, because whose name is it?
It's going to be under John Reed. I apologize, Your Honor. I'm covering for him this morning.
I just wanted to make sure I'm looking for the right place. There it goes.
Mr. Hatton has 2 cases on the court's morning docket this morning, 19 CF 3083 and 22 CF 1069. Judge, Mr. Reed did file a motion to set bond. However, in my conversations with Ms. Sandler, we are going to withdraw that motion to set bond based on Mr. Hatton's designation as a violent felony offender of special concern. Last week, Mr. Hatton's cases were continued to the April pretrial conference date, so we just asked that these matters also be put on that court date as well.
Very good. So we'll come back, continue all these cases until 4/12 at 9 a.m.
Thank you, Your Honor. And would the court like me to prepare an order withdrawing? I think that might be prudent.
That would be
Yes.
good to just to document the possible.
Absolutely. Okay. And Judge, that is all I have before the court. May I be
Thank you.
excused? Thank you.
Mr. Rare.
Good morning, Your Honor.
Good morning.
And Judge, I have Justin Terrell Chivers, President approaching under the fellow list. And Your Honor, we've reached an agreement with the state on the violation of probation. Could I approach?
Thank you. Would you please announce?
Yes, Your Honor. In 16 CF 3024, Mr. Chivers would like to admit the violation. There's an agreement for an adjudication of guilt, credit for time served, reinstate probation. There'd be a $100 cost of prosecution, a $529.55 cost of transportation, 2 years DOC, suspended, complete original terms and requirements.
It was the state's agreement, Your Honor.
Very good. Mr. Chivers, would you please raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth to help you?
Yes, sir.
Mr. Rare, so is this a downward departure
Yes, it is, Your Honor.
based upon?
Legitimate, of course, plea bargain with the state.
And Your Honor, we did review the totality of the violations. We believe it's appropriate.
Is the defense in agreement with this question?
We are, Judge.
Mr. Chivers, you heard your attorney state the terms of the plea agreement regarding your violation of probation, and I see that those same terms are contained in the written plea and sentencing agreement that you signed. Have you gone over this agreement in detail with your attorney to make sure you understand
Yes, sir.
the legal ramifications of this? Because by doing this, you're waiving some rights, the right to contest this at a formal hearing and basically say this stuff didn't happen. You're waiving those rights in order to get this, basically this agreement. Is that what you want to do?
Yes, sir.
Okay. And you feel comfortable that you've asked all the legal questions you need of your attorney?
Yes, sir.
Okay, and you're entering this freely and voluntarily, nobody's coercing you to enter into this?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. There'll be an admission of the violation of probation and adjudication of guilt. You'll get credit for time served, so you'll be able to get out of jail, pretty much immediately. We're going to reinstate probation. Their cost of transportation and cost of probation. You will receive a 2-year Department of Corrections suspended sentence. You know what that means, don't you? You had that explained to you. It means you're very much closer step away from those being exercised. So pay attention to the original terms and conditions which you're going to be bound by. Just stay on top of these things. Stay in touch with your probation officer and do what you need to do. Okay? We want you to be successful, but you know, you're one step closer to having a result you're not going to want. Okay? So you got a chance, so let's get it right. Okay?
Yes, sir.
Thank you very much.
Your Honor,
Yes.
Officer Duty State Probation, Mr. Chivers is JLA.
I'm sorry?
He's JLA.
Yes.
So he'll be needing to hook up to GPS before he's released from county jail.
Very good.
And we'll send a message out to
Do
probation.
we need to put that in the plea that?
I think it's a standard condition of his probation, Judge, that was previously ordered due to his sex offender designation. I don't think we need a specific written finding for it.
Okay, but thank you for making sure that's clear, that needs to be done.
And that's all I have this morning, Your Honor. Thank you.
Thank you, Mr. Flaherty.
Good morning, Your Honor.
Good morning.
Tim Flaherty on behalf of Jason Junkins with a J.
Okay.
Mr. Junkins was not transported per our request, Judge. We have a waiver. This case had originally been set on this docket for a motion to set bond on a different case. It was on 22 CF 2948. We withdrew that motion to set bond because there's now another new charge that has since been filed, and that's the 23 CF 363. That charge triggered both a revocation of his bond as well as another violation in his original case. So there was no reason to go forward with the bond motion, so we withdrew that last week, but then it was still set for today for a status.
Okay. I thought it was withdrawn. I pulled it off my docket, but.
Yes, sir.
So what's the status? Do we need to take any action today?
All we're requesting at this point, Judge, is to track the 23 case with the 22 case, which I believe is set for 410 pretrial.
Okay.
What was the last one, please?
Junkins with a J.
Junkins, Junkins.
Jason.
Sure.
And then, Judge, we had also filed a motion to...
We just want to make sure you're...
Okay, I show these cases set for plea day on March 14th and pretrial conference on April 12th.
Do we still need that plea day?
We do not, Your Honor.
Okay. Thank you.
And if we could move it to the 410, just because that's where his other case is set.
Is he an inmate?
He is, Your Honor.
Okay, so it'd be 412.
412, okay. And then on the 23 case, Judge, we had filed a motion to relieve the public defender. I do have an order to present to the court on that, if I may approach.
I think you have to file it through the portal. You know, can you accept it? They want us to put it through the portal, right?
We also submitted it through the portal, Judge, but if you wanted a hard copy, I can hand it to you, or we can do it through the portal. That's all I have then, Judge. Thank you.
Okay, thank you very much. Okay. Mr. Keach?
Morning, Your Honor. For the record, Jeremy Keach, State of Florida versus Matthew Strunk, STRUNK, 20 CF 2906 and 21 CF 856. Both of these cases are violations of probation. I spoke with Mr. Rogers from the Office of the State Attorney today, and yesterday he conveyed a new offer that will be open until a week prior to the next court date. We do need to set this matter for an evidentiary hearing in the event that Mr. Strunk does not accept the state's offer.
Okay. So, do we want to set it now or set it?
I think setting it now, and I can convey to what I spoke with Mr. Rogers about doing is conveying to him a week prior whether or not Mr. Strunk intends to accept it, because his intention is to revoke that offer a week out of the evidentiary hearing anyway. So if we could just coordinate a date for that.
How long do you anticipate the hearing? Half hour?
30 minutes?
30 minutes.
30 minutes.
Yes, sir.
From yesterday in this month, the 14th and the 21st are pretty much. 21st is a whole afternoon. I think April 11th. April 11th.
Perfect.
Afternoon.
That you said that's afternoon?
Longer hearings are all. So we have another, no, it's probably at 1:30 because I don't think we have an arraignment that day because that's a new day. We've got an additional day on April 6th. Would you rather do it on the 6th of April or the 11th?
Judge, I think I prefer the 11th.
Okay, we'll keep on the 11th.
And that's at 1:30?
The 11th would be at 2:30.
Okay. Perfect. That concludes my business for today. May I be excused?
You may. Thank you. Mr. Stokes, are you ready to go? Okay. Is Mr. Dees here? Any other private counsel? Very good. We have a few folks that are here today on violations of probation that do not have attorneys. So we're going to call you, and if you would, come forward to the podium when I call your name. Because you don't have an attorney, you do have a right to have an attorney if you can't afford one. So I'm going to ask you whether you need to have an attorney appointed. That would be provisional until you get your form filled out, and etc. And we'll enter a denial and place you forward on the next docket so that you can talk with your attorney. I'm just kind of letting you know so I don't have to repeat it every time. So we've got, my count, we've got 7 individuals without attorneys. So if you'll come forward, just one at a time, beginning with Mr. Michael Epps. Just come to the podium here. Would the state announce?
Yes, Your Honor. Mr. Epps's case number is
20 CF 1554. Mr. Epps, you're here on a violation of probation again. You wish to have an attorney, or are you planning on getting a private attorney?
Yes, sir.
You want to have an attorney appointed? No? You don't want an attorney?
Your
You don't
Honor.
have to have an attorney, but I want to ask you if you want one. Has there been some discussion with the state?
Your Honor, not that I can recall that Mr. Epps and I had a conversation, but I believe that this was a violation for not completing community service hours, if I remember correctly. The state's offer was going to be for him to, oh, I'm sorry, Judge, it was for not paying the cost of supervision. The state would be amenable to revoking and terminating his supervision at this point.
And what about
And the liens would go to, the financials would go to a civil lien.
what's the amount? Hold on.
The violation report says he's $359.05 in arrears.
Okay. You got some,
I paid it last week.
you paid it last week?
Your Honor, may I give this copy to probation?
Sure.
Your Honor, at this time, the BOP is going to be withdrawn and his probation is terminated.
Okay.
He has paid.
So that's why you were hesitating, because you already paid this stuff. So probation's terminated, you've completed all your terms. Okay, sorry to bother you, sorry they didn't get that squared up before. Okay. Next is Lorenzo Gordon. If the state would tell us what the status is of these as they come up.
Your Honor, that's in 19 CF 3308. This is Miss Sandler's, and she has stepped out, so we're
Good morning, Mr. Ketchum.
Good morning.
Yes, sir.
You want to pass on this and wait till Miss Sandler comes back?
If I could, Your Honor, she's not too far away.
Okay, just hang for just a little bit. We get the state attorney who's handling your case
Yes, sir.
is out in the hallway.
Yes, sir. Mr. Ketchum, I just want to bring to your attention that...
Hold on. Let's wait for the state attorney. I can't deal with anything without hearing from her. She
Yes, sir.
may be able to get everything resolved.
Yes, sir. Thank you.
Okay. Next is Bridget Hanshaw.
Your Honor, that's also Miss Sandler's case. We will.
Okay. Next is Casey Sally.
This
Who's this?
is mine, Your Honor.
Mr. Rogers? Can you announce and kind of give us an update where we at?
Yes, Judge. This, I'm presuming, is Ms. Casey Sally, case 19 CF 3386. Ms. Sally is before the court for an alleged violation of probation based upon a failure to complete community service hours and pay costs. The state would be willing, and I'm being handed something. Wait, please, thanks.
What was handled?
It was a community service hour sheet, it looked like, Your Honor. Not something I typically look at, so it's been handed to probation for them to see if it's sufficient.
So, are you thinking you've completed everything, ma'am? Is that what?
Yeah, except for my payment.
Okay.
So, assuming that the community service hours are complete, I would be willing to dismiss the violation of probation and send the cost to collections if Ms. Sally was so inclined, Your Honor.
Does that work? We'll go ahead and
Yes, sir.
dismiss the probation or terminate probation. And what is the amount?
I don't have any more cost to you, Your Honor.
I made a payment this morning, I believe it was, yes.
Are you showing anything?
I have a zero balance on this case.
And probation, are you guys seeing any costs that are due?
She has cost of supervision in the amount of $780.29.
Okay. 7 what? I'm sorry. Repeat that, please. Repeat how much?
$780.29. I did make an $80 payment this morning.
Okay. So we'll just send that to collections, and so you can continue to pay it down. Get it to work.
Doesn't collect on probation case.
Well, how does that work? Help me out.
Your Honor, the state is, I would be fine with the cost of supervision being waived. It sounds like, I'm sure that was a possibility available to the court at the time of sentencing. I'm fine waiving the cost at this time.
Very good. Okay. The court's waiving the cost of supervision. Your probation is terminated. You're done.
Yes, sir.
Does she need to do anything?
No, Your Honor.
Will she receive a copy of that in the mail that she's completed everything, some for her records, or
Your Honor, it's
just
not
let her go and?
It's not something my office would typically send out.
I'm going to see my probation officer when I'm done with this. So.
Okay, that's good. Thank you. Holly Snowden. State, would you tell me what things that?
I'm assuming. So this is 19 CF 1894. This is a first appearance on a violation of probation for a positive drug test, Your Honor. Probation has recommended either drug court or Keaton for Ms. Snowden. The state is fine with either of her choice.
So, Ms. Snowden, you do have a right with this violation of probation to have an attorney appointed. You wish to have an attorney appointed so you can kind of get some consultation with regard to the different options?
I do, Your Honor.
Okay. So So the court will appoint the public defender. You still have to fill out the form to make sure that you qualify. But I'm going to appoint the public defender. I'm going to enter a denial at this point, and we'll come back. Both of them are pretty full, but probably.
On the morning, I show you only have 10.
March 21st?
Yes, sir. It's the afternoon that's so full. Of course, there's going to be more.
The afternoon should only have one on it, 'cause that's the one that has a 3-hour hearing.
I've got
Anyway, we need to go back. Let's talk about that.
but yes, March 21st at 9.
March 21st at 9 o'clock. Ms. Samuel, you want to double back on yours?
Yes, Your Honor,
You're
thank
just
you.
handling some of the violations that have no attorneys. First one is Lorenzo Gordon, which is 19 CF 3306. Mr. Gordon, you can come forward. Would the state announce, please?
Your Honor, we're here on Lorenzo Gordon, 19 CF 3306. He's charged with a violation of probation. Right now, the recommendation is 90 days in the Okaloosa County Jail, revoke and terminate, $100 cost of prosecution, and any arrears to collections.
Okay. So, Mr. Gordon, you do have a right with this new charge to have an attorney appointed.
Yes, sir.
You wish to have an attorney appointed?
Yes, sir.
Okay. So the court's going to appoint you the public defender. You still have to fill out the form. But I'm going to go ahead and enter a denial on your behalf so you can talk with your attorney, and we'll come back on 3/21 at 9 a.m.
Yes, sir.
to kind of figure out where we're going.
Okay, but actually, Mr. Ketchum, I'd like to bring to your attention, I just made a $400 payment on the cost of supervision, and I'm expecting a tax return, so therefore I'm pretty positive, most positive that I'll be able to pay out the rest of the cost of supervision if that can revoke, terminate the 90-day jail time.
You know what the violation is, so, Ms. Samuel?
Your Honor.
What is this violation?
If I could be reinstated.
Hold on.
Yes.
The violation is untruthful report to the probation officer.
Anyway, let's do this.
Yes, sir.
Talk with your attorney.
Okay.
You're not giving up any options.
Yes.
Talk to your attorney so they might talk with the state and figure out kind of where things are going, okay?
Yes, sir. Okay, thank you. All right, yes.
Okay, we'll come back on the 21st of March.
Yes, yes, sir.
Talk to them before then.
Thank you, sir.
Yes.
Put that out before you leave the courthouse, sir.
Turn that into Bridget Hanshaw.
Your Honor, Ms. Hanshaw contacted the office of the state attorney this morning. Her car broke down in Pensacola. She also tried to contact the probation office. She is homeless, and she wanted to let the court know that she is unable to appear this morning. The state is not inclined to ask for habeas based on her honesty in her contacting probation and the office of the state attorney. Based on the fact she is homeless and the recommendation is 30 days of incarceration, we would ask the court to appoint the public defender.
Okay. Court will appoint the public defender, and we'll come back, when we come back on 3/21 at 9 a.m. I'm going to go ahead and enter a denial on her behalf, and then we'll at least the chance to talk with counsel and figure out where this case might go. Okay?
Thank you, sir.
You ready, Mr. Stokes?
Yes, Your Honor.
I think that's the last of, oh, there's one more no attorney. Is Sonny Wood here? Mr. Stokes, let me do Mr. Wood here, and then we'll get your case. Who's handling this for the state? This is 20 CF 1143 and 20 CF 3099.
Mr. Wood's also here on 20 CF 1143.
Yes, 20 CF 1143 and 20 CF 3099.
Thank you, Your Honor. Right now, the
Both
state-
are violations.
Yes, right now, the state's recommendation is to admit 90 days in the Okaloosa County Jail, revoke and terminate probation.
Okay. Why don't we do this? Ma'am, sir, you do have a right to an attorney with these new charges. You wish to have an attorney appointed, or are you going to hire private counsel? They're offering you jail time. I see, at this point, that's just an offer. You need to talk about it with your attorney and figure out where you need to go. Okay. You wish to have an attorney appointed? Okay. Court's going to appoint the public defender in both cases. It's provisional until you fill that out. I'm going to enter a denial on your behalf. We'll come back on 3/21 at 9 a.m. so you can talk to your attorney, figure out what your options are, okay? Okay. Okay, now Mr. Stokes, sorry. Thank you.
Matthew Sweeney. We're ready for Matthew Sweeney. Sorry, Your Honor, we had him at 1:30 as well, so I wanted to make sure we... He's also on 1:30 docket, I wasn't on the
What's that? He's at 9 a.m.
He's on the docket.
There's a new case. Elaine, at 1:30. Okay, why don't we go ahead and announce, you think you've got 3 cases, you can deal with the new case, new law case as well, assuming you're on that. Actually, you're listed on that.
Yes, Your Honor. I've spoken with the state.
Hold on, let's get it announced. 2020 CF 1460, 2020 CF 1637, those are here on status call, which I'm not sure what it's here for, and then there's a new charge, 23 CF 203, which is an arraignment this afternoon at 1:30, which we can handle now. So where are we at with it? Okay. Why are we here?
Your Honor, the 2020 cases, he failed to appear for sentencing in those cases. And then when he got picked back up, he had a warrant for the new case, which has become the 23 CF case. Your Honor, I'm speaking with Mr. Stokes. There is a possible concurrent agreement that we could come up with. We just need a little more time to work out the details so we can place him on the next miscellaneous docket or the next pretrial docket. I think we should be able to work these out.
That's my understanding.
Okay. So is March 21st sufficient time? It's about a month. You got that sufficient time?
Yes, sir.
I believe March 21st will be sufficient.
Okay, that's the soonest one we've really got. Okay, so we'll continue these until March 21st at 9 o'clock. And on the new law charge, the 23 CF 203, are you entering a not guilty plea?
Yes, you are.
Okay. So the court will enter the not guilty plea, and we'll come back on that one on 3/21 as well, okay?
Yes, sir.
And all of those are at 9 o'clock. Okay, anything else we need to deal with on this one today?
No, Your Honor. Thank you very much.
Thank you, Mr. Stokes. two other private attorneys,
Looks like they're not here.
Mr. Dees, and then Dwayne Sheldon, who has an attorney, Benjamin Buck.
Your Honor, those are my cases. I can tell you what I know about Mr. and Fat's case. That's 22 CF 183. Your Honor,
We really, I need to have an attorney and the defendant here, unless there's just some procedural.
Yeah, that's, I have not spoken with Mr. Dees, and I don't know why he's here, but I can tell you that it's.
There's a violation of probation was listed, was that filed?
Yes, and I can tell you that it was anticipated that Mr. Efat is going to enter mental health court. That may be why Mr. Dees is not here. I don't know that for sure. I'm just updating the court about what's going on.
Okay.
He has not entered the mental health court agreement yet. I know he has been observed.
Somebody, when we take a break, if you'll get a hold of Mr. Dees' office and tell him that we're waiting so that we can handle the case. Is is he here?
I just asked him, but he's answered back, so it doesn't look like it.
He hasn't been. So he wasn't.
He has not appeared here, and I just asked all the other courtrooms if they see Mr. Dees and no one.
No, not Mr. Dees, the
Mr.
defendant.
Efat is here, yes, sir, he is
Okay.
here, ready to go.
Okay. That's right. Okay, and what about Dwayne Sheldon? Do you have any procedural?
Your Honor, it was my understanding of what's going on in this case that Mr. Keach, who's listed on the docket, has
He is, but
withdrawn.
there's been a substitution. I think Mr. Buck would file the notice.
I have no information for the court about that, and I don't, it says motion hearing on the docket. I don't see a motion filed, so I have no idea, honestly, I have no idea.
I had a question mark next to it myself, but I couldn't find any motion either, other than the motion to withdraw.
Correct. And I thought that had been resolved because there was an order appointing Mr. Buck. I don't know what motion.
Defense filed motion to withdraw on 2/9/23. Defense request to represent himself in the schedule for right after today at 9.
Oh, well then he's here.
That's what I wrote on the minutes.
Okay. Well,
Now that the clerk is stating that, I do recall Mr. Shelton
Okay, so-
wanting a Ferretti hearing.
let's handle him after the break.
Gotcha.
Okay,
Thank you, Madam Clerk.
thank you.
I had forgotten that occurred, but now that you mention it.
And when was the Feretta request made?
On February
Thank you, Mr.
15th, last
Sheldon.
month.
Sheldon, we're going to get on way later in the document.
Your Honor, if I may,
Yes, ma'am.
I did hear back from Mr. Dees. He apologized. He's about 45 minutes out. He tried to leave a voicemail with Miss Eileen, but he is coming from Mr.
Okay,
Dees.
so we'll just wait for him. Okay, so that deals with all, so we'll begin with, Mr. Harper just has one, or the regional conflict, is he here?
Does anybody see Mr. Harper?
Okay. So we'll jump over that and we'll do some of the public defender. Mr. Gates, you want to roll? You ready?
Yes, Your Honor.
Have
We
we got
got in
some-
custody, out of custody. Majority of mine are in custody.
Okay, you want to do out of custody first? I just go down through the list, but I'll be glad to do out of custody if that.
I have one that might be out of custody, Your Honor, and I do not.
Kirkland, Ursula Kirk.
Yes, Your Honor. I do not see her in court.
Your Honor, the state's going to announce a dismissal of the VOP in Ms. Kirkland's case. The VOP was filed, from what I can see, based upon failure to appear in a misdemeanor matter. That FTA was subsequently dismissed, so
Okay.
I don't think it's
Very good.
appropriate for the
So
state to proceed.
Court will note the VOP dismissal if you need to paper that, that'd be good. Mr.
Yes,
Gates,
sir.
I'm sorry.
Yes, Your Honor, and her probation officer was here yesterday. Ms. Kirkland has some mental health issues and is homeless, so it's hard to get a hold of her, and we were trying to get her into court today, so
That's all. They're dismissing it, that's the main thing, we're getting a resolution.
Yes, Your Honor.
Probation is reinstated.
And that's my only out of custody, Your Honor.
Okay.
Mr. Morrow, you got any more?
You got a couple.
Mr. Jutroff?
What was that?
Ryan Morrow for Mr. Jutroff, Your Honor. This is 22 CF 500. The case is VOP. This is my first meeting with Mr. Jutroff. I'm handing him a card with my name and number on it.
Whoa. I'm Jutroff. Very good.
Yes, Your Honor.
Trying to find your cases.
J.
Okay.
I'm going to ask the court to consider continuing this to the March docket to afford me an opportunity.
Is this the first time up on this?
My file tends to indicate that, yes, Your Honor.
22 CF 600?
500, Your Honor.
500. This first time up?
It is, Your Honor.
So are you entering a denial, counsel?
I am, Your Honor.
Okay. So the court will enter the denial, and when do we want to come back? 321, is that?
That would be fine, Your Honor.
321 at 9 o'clock. And in the meantime, meet up with your attorney so you can kind of look at your different options. Okay?
Yes, sir, thank you. Sure.
Okay, I've got a Gus Curley, Mr. Morrow, is that? Showed him being as Gus Curley here?
Ryan Morrow for Mr. Curley, Your Honor. This was passed from last week to afford Mr. Curley an opportunity to confer with me. I do not see him in the courtroom today.
And has he conferred with you?
He has not.
And what is the state requesting?
Your Honor, the state would request capias.
Court will issue no bond capias.
Yes, sir.
So,
Your Honor, I believe I have two more out of custody. I have Mr. Donald Frazier.
okay, hold on a second. I don't have Frazier for you. What number?
I have 21 CF 1956, Your
You can
Honor.
come up, sir.
It was an add-on, Your Honor.
What's that?
It was an add-on.
When was it added on?
Yesterday. I just got the printout this morning.
Okay, that's all right. We're going to be setting some guidelines as far as when the add-ons can come in, because, you know, we try to limit the chaos. to some
Your Honor,
degree. Would you announce the case number?
Yes, Your Honor. It's 21 CF 1956. I would enter a denial on behalf of Mr. Frazier. I'd ask the court to
And
consider.
is this a VOP?
Yes, Your Honor, it is.
The court will enter a denial, and we'll come back on 321 at 9.
Thank you, Your Honor.
Are there other cases that were add-ons too? What are your other
I
cases?
may have had a few, but I have one more.
What's your other one? You're good, Mr. Frazier.
My other matter, Your Honor, is Mr. Solon's matter. He has two.
Slow down, counsel. Would you state it again?
Mr. Soul.
Soul?
Yes.
S-O-L-E?
S-O-W-E-L-L, Your Honor.
Okay, I don't have that on my docket either. Is that a add-on?
I don't believe that one was, Your Honor.
Your Honor, just a clarification on Mr. Frazier. He was given notice to appear back on January the 6th for today's date. So, and I had another one I emailed the clerk on this morning that had the court date today that subsequently got changed to the 14th. So I don't know what's going on.
I haven't had a chance to look into that one yet, but as far as Frazier, Your Honor, it should be on your docket. I found it on page 16 in Soul. I find this case on page 18.
I don't have a page 18. That's my...
His docket gets printed
That's the
before the
Frazier.
latest docket.
Okay, the updated docket that I sent yesterday has
Okay.
Mr. Soul on there.
Okay, but I was in court all day yesterday, so I didn't read the new docket. So we'll get that straight now. We just have to get our timeline so we can all be aware of what's on the docket. I'll be glad to handle Mr. Soul as...
So, Your Honor, I can jump in here. There's a waiver of appearance.
What is the case number and how do you spell it again? S-O-W?
S-O-W-E-L-L, Your Honor. The first
Okay.
name is Jeffrey.
Jeffrey, and what is the case number again? I'm
And
sorry.
the cases, Your Honor, are 19 CF 360 Foxtrot and 19 360.
360, okay. And this is also a
And then
VOP?
also, Your Honor, is 19 CF 689 Foxtrot.
These are both VOPs?
Yes, Your Honor.
Is this the first time up for these?
It is not, Your Honor. It appears this one's been floating around for a while in your division, but I've spoke with...
It has, and if I can just jump in, Your Honor, the alleged VOPs in this case are based primarily on new law violations in Alabama, 2 separate counties in Alabama, actually. I've inquired with the jurisdictions in Alabama where those cases are pending, and both of those matters are currently set for trial on May 22nd. I believe it would be appropriate if the court is willing to continue this hearing out until past that date so that I can acquire either confirmation from those jurisdictions that Mr. Solo has been convicted or that those cases have been dismissed.
Was there a denial previously entered?
It's my understanding there was.
If it was, Your Honor, it was before I was on the case, but for the record, I would re-enter the denial.
That'd be with me, yes, Your Honor. I entered the denial previously. The other issue is with Mr. Solo is he has been scheduled for surgeries due to neck injuries, and some of that stuff has been scheduled, and we're trying to get rescheduled.
Sure.
So that's probably why he's not here, is because he's probably recovering from that neck surgery that he had. I know he's been letting Officer Keene know, or Morales know pretty regularly on that.
So when is the trial? You said May?
May 22nd.
Madam Clerk, do we have a miscellaneous after May 22nd?
Yes, Your Honor. June 13th.
So we want to come back June 13th at 9 a.m. on the violation of probation, and that'll be in the morning without subpoenas. Basically, it's not called a status, but we'll determine where we're going, if we need a trial or whatever.
Understood.
There's a denial on the record. That's all we need to have at this point until we get some resolution of kind of where we're going with it.
Yes, Your Honor. I'll let him know. Thank you.
Sure, thank you.
Yeah, this is Mr. Richard Hollowback, number 17 on the court's docket. I'm going to say on the new docket, I don't know.
Do you not want me to send an updated docket? Because I don't want to use the board.
Well, let's talk about it now.
Your Honor, this is actually set as a status based upon the conversation with Ms. Sandler in this case. There was some back and forth on the autopsy photos, whether...
Would you announce the case number?
Yes, Your Honor. It's going to be 22 CF 2885.
Okay, go ahead.
Yeah, in essence, Your Honor, it was a status to see what we needed to do to get the autopsy photographs released in Mr. Hollowback's case. The state had explained this morning that it's their understanding that I need to file a motion in order to have that released. I'd like to look at that a little bit and then file an appropriate motion if necessary.
Is the state opposed?
Your Honor, the state's not opposed to releasing the autopsy photos. The state just asked for a protective order from the court to prevent both parties from releasing them to the media, something of that like, since it's pending criminal
It just seems like what needs to have is some discussion between you all as to the form of the order. If you'll put in the order, in the motion, you know, that it's agreed to or not opposed, you know, the form of it, and get me an order, I'll sign it. And just make sure and refresh me when it comes to me that you all have discussed this and the state's in agreement.
They send a stipulation, Your Honor, but given the nature of the charges, I'm leery to sign a stipulation given that we're looking at a second-degree murder.
That's fine.
And
then file the motion and let's set it for a hearing.
Yes, sir. And the state's aware I'm not planning on objecting to the limitation. I just needed the court to tell me that that would be a court order and I would follow that. And that's what I've explained to the state on this one.
I mean, the main thing is we don't want them released to the media or inside the jail. And that's our only thing. The way the statute's written, Your Honor, is it does exempt autopsy photos from criminal proceedings. However, it does allow the court, upon good cause showing, to apply some of the limitations in that statute. So we're not trying to prevent them from going to the defense at all. It's just that the statute's written in a way that doesn't allow the state to give them out like that.
both of y'all are taking very reasonable positions. He wants to be ordered because that has a little more stamp of authority if it's a court order rather than a stipulation. Not sure that's entirely true, but if it's an order, it's an order, whether by stipulation or otherwise. But I just want to make sure that clearly the good cause is shown there's a necessity for these, but I also wholeheartedly agree that there should be certain requirements by way of a protective order to make sure they're not distributed media or whatever that would be appropriate. I'm just trying to figure out the wording of that.
For Ms. Henley filed or sent the stipulation, we could just reword the stipulation and file that as a motion, and the order would be exactly the same.
The state had suggested that previously. We can work on that together.
Okay. If you can get me a proposed an order with a motion in order.
Yes, sir.
I think I've laid out. I think there's a good cause, certainly shown.
Yes, sir.
But the court is interested in hearing the state's specifics with regard to the protective order to make sure that that portion of it is properly protected with the precise language.
Yes, sir.
Okay.
Thank you.
Thank you very much.
This is for the motion that was filed by the state on January 23rd, so it's now agreed upon with the parties to confer and file a new motion in order for signature.
Yes.
I think that would be reasonable.
Yes, sir. Okay. Thank you.
Take care.
Mr. Dees? I understood Mr. Dees was here. Did I mistake that?
I haven't seen Mr. Dees. I saw Mr. Keach, but not Mr. Dees.
Is there anyone else in the gallery that believes they have court here today? Everyone else is here to see an inmate?
Would somebody also try to get a hold of Mr. Harper and let him know he has a case today as well? Okay.
We're ready to load the inmates in. You see your inmate list since the regional conference was not here. We'll start with number 8 and just go on.
Let's go.
Vincent
First.
Garcia. Yeah. Unless he does anything else first. Let me just make
Mr. Garcia, I do believe is going to be number 15 on the docket, Your Honor.
Female first?
Female?
Yeah.
This is Miss Gordy, correct?
Yes.
Okay.
Connor Steve Medina with Erica A. Cordy, 23 CF 1217, 20 CF 563, 16 CF 2347. It's my understanding that there's a 3-year suspended sentence that the state, at a minimum, would be seeking to execute in her case. So I don't think we're going to get it resolved today. It may need to be set for basically, let's leave it on April 12, pre-trial, to see where we stand on the new law in terms of getting discovery. There is a new law case that's a possession of controlled substance type situation.
Is that the basis of the BOP?
I'm not sure it's the sole basis, Your Honor.
It's one of them, Your Honor.
Okay. The state concur, we
Yes,
continue
Your
to
Honor.
412?
I think that's appropriate.
Okay, very good.
What's the bond for today? I mean, I would really like to
That's
be.
not before the court.
I'm sorry.
That issue is not before the court. What's that?
I'll put you on.
Hold on a second. I've got this listed.
This was a bond hearing today.
This listed as a status. I don't know what status means. So tell me, what are we here up today on? Is this the first time up? Is this
She
just
was
a
here
continuation?
I was here last Tuesday.
She was here on a plea day on the new law case. We entered a plea of not guilty. She was returning today.
So this is the new law case?
Yes, she needs to know, this is for the VOP. She needs to enter denial on the VOPs today.
Okay.
So that
What
this
is
was
the
the VOP arraignment that we didn't waive, so.
Okay, yeah, I mean, it doesn't have that listed on my docket.
Right.
What is the case number of the VOP?
The VOPs, Your Honor, are 20 CF 563 and 16 CF 2347. And Miss Cordy, I believe she has a prior last name of Kerfine, Kerfien, so she may be down on that case, that name for 16 CF 2347. And I assure her that I will file a bond motion. I think based on my understanding of the court's calendar, it would probably be March 21st before I could do a bond hearing.
Your Honor, can I address?
It would be better if you didn't address the court, if you want me to represent you.
I would like to get new counsel, please, if I could. I do not.
File that too.
How do I do that?
File a motion. File something, say I want a new counsel and tell why.
I don't feel I'm being adequately represented by my counsel.
That's fine. You have a right to do that.
Okay, that's called a Nelson hearing, and you have to have good grounds, so you can.
I would like to fire you as my counsel. I do not wish to
If she wants to represent
I'm sorry.
herself, she can fire me at
Okay,
any time.
that's fine, but let's do it right. So file something and we'll get it before the court, okay? What I'm trying to do is figure out what cases are on the docket today and what we're doing. This case 23 CF 127, why are we on this docket today? It says status. That's the new law chart. Is that a VOP?
We were on the docket because of VOP arraignment, which was not previously conducted to my knowledge.
And what were the cases of the VOP arraignment? Is that one of the 20 CF cases? See, those are not on my docket, Mr. Medina.
I'm not sure about the docket, Your Honor. Those are her VOP cases.
Okay. I'm just trying to follow my docket.
Yes, sir.
Don't get anybody get mad at me. I'm just trying to keep everybody organized because I'm in charge. I'm trying to keep this ship moving straight. Okay? So the court will enter denial on the violations of probation and the new law charge. Why is that on the docket today?
Because in the unlikely event that there was going to be a resolution, which there's not, we wanted it also, the prosecutor would have her file and I'd have my file, Your Honor.
Okay.
But it's not going to be resolved today.
Okay, so we've got the two VOPs, their denials, and we'll run them all together and we'll come back on 4/12. If you need anything before then, let me know. Thank you. Did you get the VOP number?
Yes, sir, I showed that you put them on today's docket for last week.
Vincent Garcia.
Likely done as a status for potential plea, Your Honor, to cover both cases. Mr. Vincente Garcia, number 15 on the docket, VOP arraignment in 19 CF 699, 22 CF 1718.
What's the first number?
19 CF 699.
Okay, that's also not on my docket. So, are those both violations of probation?
Yes, Your Honor.
Is this the first time up on?
It is, Your Honor. Your Honor, I spoke with Mr. Garcia. The state's offer today would be a DOC sentence. At this time, we'd like to enter a denial to cover both cases. If we can set him for March the 21st.
Very good. The court will enter a denial and we'll come back on March 21st at 9 a.m.
Does the state need to set that with subpoenas?
Without getting some information, trigger option for him. People can use it.
Derek Gomez.
Yeah, this is Mr. Derek Gomes before the court in 21 CF 2890. Should be number 16 on the docket. Mr. Gomes also has 23 CF 216 on the afternoon docket, number 8. Your Honor, we have a plea agreement to be filed that'll cover both cases. I gave that to Mr. Gomes this morning. He and I discussed it before he came out. I just need to get him to sign the plea agreement, Your Honor. Very good. I'd like to let Mr. Gomes review the score sheet, Your Honor. Sure. May I approach up? You may. Thank you, Your Honor. Thank you. No objection to the score sheet. Very good. Your Honor, Mr. Gomes will be omitting the violation of probation in 21 CF 2890 and pleading as charged in 23 CF 216. He'll be adjudicated guilty all counts and cases. In 21 CF 2890, we're going to modify and reinstate probation. That'll be concurrent to probation that'll be announced in 23 CF 216. $100 cost of prosecution, $150 public defender fee, required to do an additional 50 hours of community service work, which cannot be bought out. You must complete the community service work at a minimum of 8 hours per week. Complete the original requirements. In 23 CF 216, 3 years of probation in count 1, which is a felony count concurrent with the other case. Count 2, year of probation, 11 months, 29 days probation concurrent, waive costs of supervision, and counts 3, 4, and 5, which are second-degree misdemeanors, time served. 515 court costs, 100 public defender fee, reserve over restitution to Mr. Barry Lott, and no contact with Mr. Barry Lott. State.
That is the state's agreement, Your Honor,
And this is downward departure.
based on a negotiated date on it.
Mr. Gomes, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, Your Honor.
Sir, you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you've signed. You can put your hand down. So, just want to make sure you've gone over this plea and sentencing agreement and the terms of it and the ramifications in detail with your attorney.
I did, Your Honor.
And you had all your legal questions answered about it?
I did, Your Honor.
You understand you're waiving the right to a trial, this is the final resolution of all these matters that are contained in here. Do you understand that?
Absolutely, Your Honor.
And you believe that's in your best interest?
I do.
Okay. Very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt on all counts, all cases. And the core of this is really the 3 years of probation, because everything else is going to run concurrent to that, and actually is less than that. But in count 1 of 23 CF 216, 3 years of probation, and then lesser probation in count 2. You will get credit for time served in counts 3, 4, and 5, which are the second-degree misdemeanors. Fees and costs There is a reservation of restitution, you know what that means? It means
I believe, yeah.
that they might file something and seek some restitution, but you can contest it if that happens. You
Okay.
do understand that's a possibility.
Yes, I do, Your Honor.
It's important that this no contact with Mr. Lott is strictly abided by.
Good.
Okay?
Absolutely, Your Honor.
Very good. Based upon that, the court will accept your plea and sentence you as contained in the agreement.
Thank you, sir.
Thank you.
Thanks, Mr. Gomes. Ronald Jacobs.
Your Honor, this is Mr. Jacobs before the court in 5 cases. It's number 18 on the docket. We've got 19 CF 2455, 19 CF 2476, 20 CF 187, 20 CF 763, and 20 CF 2380. Mr. Jacobs is also, was supposed to be on this afternoon's docket, but has subsequently disappeared off that docket, at 23 CF 248. Has the state filed information in that case?
Take a look.
Do you have the case number that for this afternoon's docket that was supposed to be on there that's no longer on there?
23 CF 248.
Looks like the state filed information on February 7th.
I'm not sure when I would have done it. Not guilty.
What's your case number again, please?
23 CF 248.
I don't show that this case was ever on this afternoon's docket. I have a felony plea for March 14th with a pretrial conference for April 10th. I don't show that today was ever on for Mr. Ronald Jacobs.
Well, if the court will allow, I'll handle it today and save us some time on the 14th.
Sure, that'd be great.
At this time, Your Honor, we're going to enter a denial on the VOPs before the court, and then enter a not guilty plea. The state has filed an information in 23 CF 248, and move him to April the 12th instead of April the 10th. It's only for non-inmates. Yeah. Custody, yeah. I'll talk to you about that.
Okay, very good. The court will enter denials and not guilty on the new law charge, and denials on the remaining 5. We'll come back, we'll run them all together and come back on 4, April 12th, 9 a.m.
Thank you, Your Honor. Come see Mr. Jacobs.
Mr. Medina, I think that's all Mr. Gates. Is that all, Mr. Gates?
For this morning's docket, yes, Your Honor, there's one other that had court that subsequently doesn't have court. I've asked court security to have transported. It's a plea to get her out of custody.
Okay.
Dante Allen.
Morning, Judge. Charles Russell, Public Defender's Office. This is Dante Allen. He is before the court on 2 cases. Case numbers are 21 CF 3092 and 22 CF 2122. Both of them are VOPs. At this time, we're going to enter a denial on both cases and would suggest to put this with Mr. Allen's new law violation, which is set for a felony plea day right now on March the 14th at 1:30, and have all the cases brought in at that time for a possible resolution.
Very good. We'll continue, we'll enter denial, we'll continue this till 3/14, March 14th. And that's in the morning, 9 a.m.
Oh, you want to do it at, well, it was set at 1:30 on the felony.
Oh, 1:30, I'm sorry.
9's fine.
Sorry, my bad.
Okay. Thank you, Judge.
Okay, so the plea day for the new charge is at 1:30 on 3/14.
Yes, ma'am, already.
And we want to go ahead and put the VOPs on a 1:30 as well for that plea day as a VOP.
Correct, because there might be a universal resolution.
Salvador Baratuban.
Charles Russell, Public Defender's Office, Judge. This is Mr. Bartuban. Case number is 23 CF 235. And Mr. Bartuban is on the docket for a bond reduction hearing. It's my understanding that the defense and the state have agreed to change his bond to a $10,000 signature bond.
That's correct, Judge.
Very good. With the agreement of the state, court will change the bond to $10,000 signature bond.
And Judge, Mr. Vertuven is set for a felony plea day on March 14th at 1:30, so we're just going to keep that date.
Okay.
Is it $10,000 signature?
That is correct, Madam Clerk.
Derek Brown. Derek Brown. Your Honor, Steve Medina with Derek M. Brown in 19 CF 2157 and 20 CF 643. I have an agreement proposal from the state that has the best offer of the state. I need just a moment to make sure he understands it. Your Honor, he's signing the agreement that he and I had previously discussed and anticipated. Do you have any questions? I don't think we have to have a score sheet against VOP, but we still. Yeah, it is. Okay. All right, you're right. So,
And Your Honor, I don't have that, I have the score sheet done, but it's not printed out and with me. Mr. Brown is gonna score 12.15 months in the Department of Corrections, but this is a downward departure based on a negotiated plea.
I just would only add that the only new law violation is an alleged misdemeanor case, so technically there didn't have to be a downward departure, if I may approach.
Right. Would you announce, please?
Yes, Your Honor. Under this agreement, the two felony VOPs, one each in 19 CF 157 and 20 CF 643, would be resolved for 10 months Okaloosa County Jail, and that's concurrent through with both cases. And that's with credit for all time served, $100 VOP fee times 2, $250 total public defender fees, outstanding monetary obligations to collections 12 months after release, revoke and terminate supervision. And I think his next court date would be whatever it is in his misdemeanor case. Oh, did you already have it?
March 6th.
March 6th, okay.
Mr. Brown, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, Mr. Brown, you heard your attorney state the terms of the plea agreement. I see those same terms are contained in your plea agreement that you signed. Have you gone over this agreement in detail with your attorney? Make sure you had all your legal questions answered concerning this. You can please answer. Did you get all your legal questions answered? Yes, make sure you understand that. States an agreement, Ms. Sharpless?
Yes, Your Honor.
Okay. And you understand that by entering this plea, you're waiving the right to go to a trial, waiving some legal rights. You just want to make sure you're doing it freely and voluntarily.
Yes, sir.
You understand this is the final resolution of these?
Yes, sir.
We missed something? Go ahead, Mr. Medina.
We didn't miss anything, but Assistant State Attorney Sharpless is being proactive and an exercise in judicial economy. His misdemeanor case, she's willing to resolve for time served.
Concurrent 10 months.
I think it was not, I don't want to add time because he would have a lot of significant time.
Okay, credit for time served, Your Honor. It's 23 MM 165.
You'll just amend it
And it is a possession of paraphernalia, Your Honor, and that's the only thing that would be left holding Mr. Brown in jail. If they did the calculation, I don't know how much credit he has, but that will get everything resolved for him.
I'm sorry, ma'am, that's 23 MM what?
It's 165.
And that's on a paraphernalia?
Possession of paraphernalia.
Thank you.
And that will add 0.2 points to the score sheet.
So I'm adding, Your Honor, concurrent time served in 23 MM 165, and that would also add a, I think, probably 200 and, or what would the court cost be? 270?
And is this going to be time served or congruent with the 10 months on the felony BOP?
It's concurrent time served. It's time served would be a better way to say it.
Okay. That's important.
Correct. Credit for time served.
Credit for time
That's what I
served on
heard her
this.
say. There was some discussion.
On
I wasn't overriding them. That's what I heard it to be. Credit for time served is the agreement, right?
Yeah, on misdemeanor, yes.
Okay.
So there would be 270 court costs and 50 PD fees in that case. You understand it?
If I need my school sheet,
Credits for time served. 270 court costs. Thank you.
Sure.
thank you.
I was made aware.
Okay, so Mr. Brown, a little bit of confusion, but we're in a positive sense. They're adding the other misdemeanor charge that you've got out there and wrapping it all into this.
Yes, sir.
The additional resolution of that charge is just credit for time served.
Yes, sir.
So, plus, of course, they're always wanting more fees, right?
Yes, sir.
Always.
Yes, sir.
So, so I just want to make sure you understand this will be a final resolution of both the violations of probation and the misdemeanor.
Yes, sir.
All wrapped up into this
sir.
one.
Yes, sir.
Okay. And again, you feel like you've had all your questions answered by your attorney, and this is being entered freely and voluntarily?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea.
Yes, sir.
And will sentence you on the 2 VOPs to 10 months in the county jail. You will get credit for all time served. On the misdemeanor charge, there will be credit for time served, no additional time.
Yes, sir.
And then you got fees and costs, all monetary obligations will go to collections 12 months after you get out.
Yes, sir.
Okay, so you got 12 months to pay, and then it goes to collections. Revoke and terminate supervision, so no more probation when this is done.
Yes, sir.
Okay?
Yes, sir.
I did need to say one more thing,
Sure.
Your Honor. I'm sure the state, and I don't think Mr. Brown would disagree, it would be an adjudication of guilt on the new misdemeanor, the
Correct.
23M.
Thank
And the
you.
other 2 cases were previously adjudicated guilty.
Thank you.
Thank you.
Credits finished.
Yeah? Yes, ma'am. Thank you.
Jonathan Bryant.
Your Honor, we're here on a status. This is a evidentiary hearing that Judge Polson had ordered, and this is a status to determine what would be the next step. I do believe, based on discussions with Mr. Bryant and Assistant State Attorney Basso, that the next step will be the setting of the evidentiary hearing that Judge Polson had ordered. And I think we should go forward with that expeditiously.
Your Honor, prior to proceeding, I would like the court to inquire of Mr. Bryant what the potential outcome would be if the court does in fact find that there were any violations on the ineffective assistance of counsel.
I'm sorry, I'm not tracking. Say that again.
This is an ineffective assistance of counsel claim. Basically, Mr. Bryant is asking for an evidentiary hearing to determine whether or not, in essence, he will receive a new trial.
Correct.
His counsel is found ineffective. Your Honor, we believe it's appropriate for the courts to inquire of Mr. Bryant if he fully understands the consequences of his request. He was charged with and found guilty of 1 count of production or distribution of child pornography and 67 counts of possession of child pornography. Based on the finding of guilt, Judge Brown sentenced him to 25 years Department of Corrections, followed by 15 years of sex offender probation. Your Honor, if he is granted a new trial, Mr. Bryant needs to understand that his exposure is actually 925 months as a minimum guideline if he's found guilty again. That's
how many years is that?
77 years, Your Honor, up to 1,035 years. That is his exposure. So if he wishes to proceed as is his right, then we believe it's appropriate for the court to inquire of him that prior sentence goes away. He doesn't get the downward departure again unless the court again finds it appropriate after a finding of guilt if a jury finds that.
Mr. Medina?
Your Honor, I don't see any basis for disagreeing with Ms. Basso's representation as to the risk that he's
I know, I agree too, but I just wanted to, I didn't want to just jump in the middle after Ms. Basso said something without giving you a chance to object or
that is the situation, Your Honor. I was assigned counsel based on Mr. Bryant's decision. He is fully informed that there would be substantial risk if he were to prevail on this issue with relating to whether his prior attorney Weinstock, and it was in any way ineffective. The remedy would be a new trial and significant exposure. So Ms. Basso is fully informed of that. It's on the record. I'm not recommending that he pursue this course of action, but it is his choice and that's what he wants to do.
So, you understand all this conversation here, you're pretty well informed of this. I've seen a lot of your pleadings and whatnot. You've obviously put a lot of time into this, but I think it is worth asking just to make sure you're aware that you have I think substantially increased exposure would not be an inappropriate statement. Do you understand that?
Yes, Your Honor, I do.
Okay. And you still wish to proceed?
Yes, Your Honor.
I understand there were some of this had to do with some documents, whether some was signed. Has there been any shift in kind of the issues that are outstanding? Because I read a little more than normal in this case.
I think that at this point, it's appropriate for the state to go forward with their case with Mr. Weinstock and his testimony, and for us to put on our case. I think that there have been exchanges that have been of information provided, but there's no stipulation, no.
What I'm trying to do is, it looks like we're going toward a hearing.
Yes.
And as with every other trial I do, you always want to focus on what the issues are and narrow them, if possible, by both parties. I'm raising this issue very lightly just to ask if there is, with this exchange of information, whether there's been any change in the issues that are before the court that we are about ready to set a hearing on.
None that would allow us to reach any narrowing in the issues, Your Honor. I think there has been substantial information provided that will have to be taken into account through the course of an evidentiary hearing.
Okay, very good. So, How long of a hearing?
May I?
Sure.
Your Honor, Mr. Bryant, we've been talking about the transfers of information from the state, and he's now indicating to me that he is willing to withdraw ground 6 of his, that was the subject of the order to show cause, ground 6, so he would proceed to evidentiary hearing on grounds 3 and 5. That's his statement. I don't see anything irrational. I think that would be in his best interest. I certainly would agree with his approach to narrow the issues, but I didn't want to deprive him of that opportunity if he wished. But you're stating on the record that you're freely and voluntarily wishing to withdraw ground 6?
Yes, after a thorough reading of the state's response and the documents attached, I am respectfully withdrawing ground 6 from, I guess I would say, the hearing at this point.
State.
The state would be prepared to proceed, Your Honor, on counts 3 and 5, grounds 3 and 5. But something that Mr. Medina mentioned, that it would be up to the state to prove our case, we believe the burden is actually on the defense to prove that it was ineffective and the state provide any rebuttal. So
we don't have to, that's up to the lawyering. Well, I don't think the court has to remind Mr. Medina of that. I think he's well aware.
But the state would be prepared whenever the court says this, take care of this.
Okay. How long do you anticipate needing for this hearing to take place? How long?
I think so. We can do it about an hour and a half, Your Honor. We really just have the 2 grounds. So.
I mean, you all ready to go today? I mean,
oh, no.
I'm just trying to figure out how far out do we need to set it.
I don't think that far out. There are a couple things that Mr. Bryant and I need to go over, and I do want to meet with him once we have a date prior to the date to go over things. We've met previously, but with the evidentiary hearing date set, we'll have a final meeting.
I was thinking either the 6th or the 11th, maybe the 6th, maybe in the afternoon.
What month would that be, Your Honor?
Well, we're looking at April.
Yes, Your Honor.
Is that?
Yeah, that's fine. It was, if you were talking March, it would be a problem, but April is.
April 6th, it's not in the system yet. Yes, it is. April 6th is in the system for you at 1:30. Sorry.
April 6th at 1:30 work?
Yeah, we're also in Division 6 that day for some reason. We're all over the
What
place.
is Division 6? Which one
Division
is
6 is your own division, Judge. Rescue. How quickly we forget.
So that date won't work for you?
Your Honor, if that's available to the court, I'll just have someone cover it for me. We'll make it work. I don't want to delay it.
Let's do it April 6th.
Oh my gosh, just this case at 1:30.
No, I want 90 minutes block. So we could probably put, a couple other short ones. Because we can start at 1:30, so that'll go to 3. But I mean, have a few more that day as well.
Thank you, Your Honor.
Thank you, Mr. Medina.
And I'm sorry.
Anything else on this case?
I didn't text the time, I'm sorry.
1:30?
1:30. Thank you, Judge.
Okay, and we'll be further up in that time. What is this case?
Your Honor, this is Mr. William Burrell, 19
Burrell?
CF 178 Alpha.
Very good.
We negotiated a resolution with the state in this matter, Your Honor. Would you like me to announce, or would you just like me to approach with the sentence?
If you would announce, that would be great. If you have an extra copy, that would be great. I can read along if you don't.
I'm going to give you this copy. I'm going to read it and then bring it to you if that's okay, Your Honor.
Okay, that's fine.
Your Honor, the agreement between the parties contemplates that the court should revoke or terminate the probation, sentence the defendant to time served, $100 VOP fee, $150 cost of defense, and 60 days to pay the financials before they reduce to a lien, Your Honor. May I approach?
You may. Thank you. Very good. Mr. Burrell, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Is the state in agreement?
Yes, Your Honor, that is the state's.
So you just heard your attorney state, you can put your hand up. You heard your attorney state the terms of the plea agreement.
Yes, sir.
And is that your understanding? I see you signed the written plea agreement. Have you gone over this in detail with your attorney, made sure you had all your legal questions answered?
Yes, sir.
I understand that by entering this, you're basically, it'll be a final resolution of this violation of probation, and you understand that?
Yes, sir.
So you're waiving the right to go to a trial, basically?
Yes, sir.
Okay. You believe that's in your best interest?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea agreement. Court will revoke and terminate probation. You'll get credit for time served, and there's some fees and costs. You'll have 60 days to pay, and then it goes to collections. Okay?
Yes,
Any
sir.
questions?
No, sir.
Okay. Thank you, sir.
Thank you.
Castillo? Is that yours?
It is, Your Honor.
Castillo?
Ryan Marr from Mr. Castillo, Your Honor. I provided some documentation to the state about Mr. Castillo's progress as to his treatment on probation. We're trying to effectuate a resolution of this matter that allows him to finish that out, and we're trying to decide the best way to accomplish that, whether that be a modification of the probation or to grant Mr. Castillo bond. It's my understanding he only has about 9 sessions left. And I'm trying to understand Ms. Sharpless's position.
I really need to look at that because we need to get with probation and figure out if we can even restart that. I don't know the answer to that question. I know that they received a report from the counseling as well. So I think we just need to figure out.
Sounds like there's a little more work to be done in order to kind of figure out how to proceed with it. So you want to...
Would it be okay if we recalled him at the end, Your Honor? I'm hoping that we can still deal with this today. This was passed from last week for this very reason.
Oh, sure, I'd be glad to.
I have Mr. D's client in the...
Yeah, I know. Let's hold. I know y'all just came here, but we need to take a morning break. If not, we'll be pushed and it'll be noon before we look at it. We'll come back and we'll do Mr. Dees and Mr. Harper first off. As soon as we come back, it'll just be 10 or 15 minutes.
Yes, sir. All rise. We're in recess for 10 minutes.
Go ahead, sir.
We'll bring out yes. Mr. Dees.
It's wonderful to meet you.
I am not.
Robert Dees on behalf of Tyree Effort, Your Honor, is 22 CF 183. He is going to report to mental health court tomorrow to enter a plea to reinstate his probation there. So if we could just, I don't know if the court needs a control date, but he is set in front of Judge Selector tomorrow.
Let's just bring back on the on our general pretrial on 4/12.
Assuming
Hopefully it'll just fall off.
Perfect. Sounds good. See you tomorrow. All right. Thanks. Probably see you tomorrow.
Thank you, Mr. Dees.
Thank you, Judge. Thanks for being patient.
What's that?
Can you take any of Mr. Griffin. Griffin. Well, I'm gonna do Donaldson for 3.
Emilius Donaldson.
Donaldson. I think it's supposed to.
Counsel.
Judge Regarden, on behalf of Mr. Donaldson, before the court on 22 CF 1617. Judge, I think we're here for basically a status. He's got a designation as a violent felony offender of special concern, and that was attributed to him at first appearance. However, the issue is that after speaking with my client and doing our own little background, I can't find that he was on probation anywhere, which would be a tier of that designation. I guess at this particular point.
So you're disputing whether the designation is proper?
Yes, sir. And if it isn't proper, then of course we would ask for a reasonable cash professional bond as to these cases, which is something he should have got at first appearance. However, if the designation is appropriate, then he's precluded from having the bond. I've spoken with the states, and I think that they're asking for some additional time to pull up some out-of-state records. So I think we might hold this in abeyance, so to speak, just to give that time. I don't know when would be a more appropriate time to set this, Judge.
Your Honor, I am, I do need some more time to look up if he is on probation and confirm the violent felony offender status so we can leave this on the next available miscellaneous date. I don't know that Mr. Harper will need to file a motion unless I disagree with him that, unless I find that he is a violent felony offender. I just need more time to look into that.
Your Honor, if we can set it for the earliest next miscellaneous court dates, I anticipate that we either proceed to bond or bond is not a possibility in this case.
Okay. So would this, I'm trying to kind of figure out, I mean, is this more or less a status to see if y'all are in agreement, or are we?
I think that this was something that was maybe brought up at the beginning of the week.
Yes, sir.
And that's why
I understand that, but what I'm saying is, do we need some type of a hearing that's going to take some time? What is the technical procedural status?
What I will do, Judge, is that whatever date we decide to set this for, and it will be for a morning bond hearing date, I'll file a notice of hearing and just notice it as such, just as a bond hearing, Judge.
Okay.
And Your Honor, what I expect will happen will be that even if I tell the court that I do, I have found that he's not a violent felony offender, we may still need to have a full-fledged bond hearing where the victim comes because his victim is cooperative and wants to participate. So we may need to, have argument about how high the cash or professional bond should be if he's entitled to it.
That will require a longer hearing, which means it's at a different time slot. So that's why I'm asking, what are we doing? Are we seeing whether we Why don't we do this? Why don't we come back at the early in the morning, because this will be the earliest slot we can get, is March 14th in the morning. And during that hearing, we're going to, if there is an issue of the designation, if it's appropriate, if the court finds at that point, either by agreement of the parties or the court makes a rule that he's not a violent felon of special concern, so he doesn't, it's improperly labeled, then we'll go ahead and set a bond hearing, because very serious charges, the victim, alleged victim, has a right to participate. We now know that, more so than years past. That's under Marcy's law. So we'll then set something a little longer, and so we'll have to reset it at that point. So we may not get. It may be a two-step process.
Yes.
Okay.
That's appropriate, Judge.
So we'll do it in the morning on March 14th.
Just so Your Honor knows, you've got 43 already set that morning.
How about 21? March, that's one. Yeah. We're going to do it on March 21st, not 14th.
Thank you, Judge.
Thank you. I meant to do it on the right.
Thank you, Judge. That's all I have today.
Thank you.
I apologize for the tardiness.
We just assume, you don't ever want to admit, you assume that you were doing something very important.
Yes, yes.
Do you want to put it on the next pretrial conference or wait? Okay.
Just wait, because we're going to see.
So that'll go with this.
Tomorrow, would you like to announce it?
I will, Your Honor. This is Joseph Cottrell, Brian Marr for Joseph Cottrell, Your Honor, 22 CF 1848 Alpha and 22 CF 2040 Alpha. This is the first time up, Your Honor. I'm going to move for a continuance to the March date. The state has no objection.
Hold on, I'm sorry, I'm getting all the paper together.
We're going to enter a denial for the record as well, Your Honor.
Okay, is this first time up for the two violations?
It is, Your Honor. And
very good. Court will enter denial, and we'll come back without subpoenas on 3/21, 9 a.m.
Thank you, Your Honor.
3/21.
She got talked to her last night. She said she's going to start fighting this morning. They're off phone at 9 o'clock. I didn't hear she's not there, so I mean, it's what she has dropped off there.
Anthony Griffin.
Ryan Morrow for Mr. Griffin, Your Honor. This is 22 CF 2457. I've provided Mr. Griffin with paperwork to enter an admission on this VOP. But in preparation for this morning's court date, Your Honor, and conferring with Mr. Griffin yesterday, I'm anticipating there to be another case coming down the pipe, another VOP. I looked on the clerk's site this morning, and it looks like, and talking to Mr. Griffin, they served paperwork on him yesterday, so I think that the best thing to do would be to make sure that that case is reopened and he's properly served, and I can properly advise after I'm...
Bring them together.
Yes, Your Honor.
Okay. Does the new one have a case number?
It's 22 CF 1240, Your Honor.
And this case number, give me this case number.
This is 22 CF 2457.
Okay.
And my client's been advised to the extent that I could before that case was reopened and appointed. He's been provided with paperwork, but I've been speaking with the state. I think the best thing to do would be to get me on that other case and make sure that he's fully advised.
Sure. So we'll continue this till 3/21 at 9 a.m. Figure out where we're going.
And does the clerk reflect whether that other case has been reopened and he's been served, and could I get appointed on that matter?
I can go ahead and put it on the minute sheet, but I don't have the arrest report yet. It just happened yesterday, and it's a violation of community control.
Right, I'm just trying to ascertain why he wasn't served with all that at once, and I'm trying to make sure that it's reopened and I'm on the case.
Yes, sir. The affidavit, you gave me the new charge, the 22-2457.
No, that case I'm already on.
Yes. I don't know what happened yesterday. Did they?
It was, what is today? Today's Tuesday. So this was Friday last week. But it was, I guess, my other warrant. It was Saturday first appearance.
Okay, that's the issue then.
Yes. We'll put the case number on, and we will appoint the public defender if you're not already appointed on the new case.
Thank you, Your Honor.
So it was done over the weekend. Sometimes they don't appoint, I don't know why, but sometimes they just don't, kind of run.
Understood, Your Honor. I just wanted to make sure I was on the
Sure.
case before I went about
That's good.
advising on it.
I agree. Okay.
So just continue.
Malone? Antonio Malone?
Ryan Marl for Mr. Malone, Your Honor. This is 19 CF 648 Alpha. He's inclined to enter admission on the VOP, Your Honor. I have not prepared the paperwork because the state did not make an offer in this matter. And I wasn't sure if the court would require it on a score of about 17, but we are prepared to go to sentencing this morning. If the court would like me to prepare a plea agreement, I will.
Say that again.
Okay. The state did not make an offer in this case, Your Honor. His score, he's below 22 points. I wasn't sure if this is a situation where the court would require a written plea agreement. We'll be asking for reinstatement and modification and allow them to finish it out. If the state's not amenable to that, they want a county jail sentence. But I didn't know if the court would require a plea agreement in a circumstance such as this one, where he doesn't score state prison and the state did not make an offer.
The only time, if there's an agreement, the only time I'm sorry,
Your Honor, there's no agreement. I informed.
I know, that's what he's saying, there's no agreement, so why are you asking whether something needs to be filled out?
Because even some of these matters where I'm pleading straight to the bench and there is and no agreement is being sentenced.
If you're pleading to the bench, you need to ask, you need to have that in writing as well.
Well then, may I prepare a quick piece of paperwork for Mr. Malone, and then I'll send that back for him. He has been advised, but...
Okay.
I'll try to type that up for Mr. Morrow real quick and get that printed so he has a copy.
Okay.
Thank you, sir.
Frank Antonio Malone needs to come back out. They're doing it.
Darren Potts.
Ryan Morrow for Mr. Potts, Your Honor. This is 14 CF 1480. And this is going to be a plea to the bench, and the VOP is going to enter admission. We're going to request of the court set off sentencing.
Is there an offer on this case?
Your Honor, Mr. Potts has a 5-year suspended VOC sentence, so that's going to be my recommendation if I don't fall off my heels first. You're right, we'll be asking the court to vacate the suspension and impose the sentence, so that would be our offer.
My understanding of Mr. Potts' last sentence was a 10-year suspended sentence.
I'm sorry, I didn't hear that, yeah.
And that her offer was for him to waive all of his prior credit and accept a 5-year sentence was her offer to me.
I signed a plea agreement last year, a 10-year suspended sentence with all credit time served. I got 79 months time served in already, so.
So we'll be asking to vacate the suspension of the sentence. But we did give him the alternative of waiving all prior credit and just having a 5-year VOC sentence. And then that way he can decide wherever he has the most credit. But we'll be asking for the 10 years.
May I approach him?
Right. Okay. Mr. Potts, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Is there a score sheet on this?
No, Your Honor, because it was an open plea, we normally would provide those at the sentencing hearing.
At the sentencing. Okay, so let me go ahead and swear. Did I swear you in?
Yes, Your Honor.
Too many cases this morning. So, Mr. Potts, you have signed this violation of probation plea agreement, and you're pleading to the bench.
Yes, sir.
So, I'm pretty sure you understand how this process works, but I just need to ask you a couple questions just to make sure you're entering into this freely and voluntarily and with understanding the legal ramifications. So you've got a chance to go over this with your attorney to understand the legal ramifications of this. You understand that the court could order a 15-year sentence? You understand that?
Well, Your Honor, with the...
No, don't argue with me. I'm just asking whether you, I'm not saying I'm going to, I'm saying you understand, do it. If you don't, say no. Am I saying that correctly?
No, Your Honor, because the suspended sentence is a 10-year, the court will be limited to 10 years.
The way it was signed, the plea was
But
signed.
in their violation, doesn't that open that back up? If there's a suspended sentence?
We capped it at the time he entered into the agreement on the VOP, it then capped any violation at 10-year, absent a new law violation.
Okay. So based on the prior agreement,
Yes,
you
sir.
capped it? Okay. So normally it would open it up, but because you all agreed to something differently then?
That's correct.
Okay. Okay. Very good. So you understand that, okay?
Yes, sir.
So essentially what we're going to do is obviously have a sentencing and everyone's going to get a chance to argue at sentencing. You will, having said that, you know, the basic resolution of the case other than the sentencing is resolved with this hearing. You understand that?
Yes, sir.
You could go to a hearing and argue that the violation didn't take place, but you're admitting the violation here today, correct?
Yes.
Okay. So that'll be a final resolution of that portion of the violation. You're admitting to that, we're going right to sentencing.
Yes, sir.
So you can't back up. Depending on what happens to that, you may or may not like what happens at the sentencing. You might not, okay? But you can't change the fact that you admitted this violation and we're moving forward with it. Do you understand that?
Yes, sir.
Okay. And you said you did have all your legal questions answered of your attorney?
Yes, sir.
Okay. And you're entering into this freely and voluntarily? Nobody coerced you to get you to enter into this?
Correct.
Did anybody promise you anything?
No, sir.
Okay. Very good. How long, court will accept your plea agreement as stated, which is the plea to the bench. What is the, how long do you anticipate needing for this?
The hearing won't be long, Your Honor. I am preparing a mitigation evaluation. I'll provide that to the state and the court ahead of time. So it will mostly just be argument. I don't know that I intend on calling any witnesses at this time.
Is a PSI required for this?
I don't believe it is under these circumstances, Your Honor. He's already been to prison, and I would likely waive that anyhow.
You said mitigation evaluation, sir. Are you having him evaluated by a doctor or something you're just putting together? I just want to be clear as far as when we accept this, because we're ready to go whenever, Your Honor.
Right, a doctor, yes ma'am, a psychologist.
No. Apparently, it's not necessary. So, how long are we?
Are you asking how long for between the next court date or how long I need for the hearing? Your
How
Honor?
long? Both. I mean, you said it's going to take a short period, you're going to get a mitigation.
Yes, Your Honor, I would ask for the
Are you
March.
going to have a witness, or are you just going to have a report? Are we going to review the report, and how long is it going to take to get that? It's not something that'll.
I called my expert yesterday after leaving the jail to ensure that if I gave him a month, it would be enough time, and he told me that it would be. So at this time, Your Honor, if you could give me 3/21, I think I'll be ready. If I needed more time, I will alert the court and the state at that time.
Well, we don't have any time on the 21st.
Understood, Your Honor.
In the afternoon, which is when it's.
I'm not sure what you have in early April, or if you do, Your Honor.
April 6th.
Sure, we'll be here already with Mr. Bryant's case, Your Honor.
Okay. One thing I ask is that any written materials, anything you're going to be submitting, you need to get it to me at least a few days in advance of that so I can prep. So I tend to, I want to read this stuff. I'm not just going to wing it on sentencing day. Okay?
Understood, Your Honor.
Get that to me. Okay. So we'll do it at 1:30 on the 6th. We're number 2 on that document right now.
Yes, Your Honor.
Robert Taylor.
We got the. Would you announce?
Your Honor, this is Mr. Robert Taylor, 20 CF 3063. I'm going to get a couple signatures and approach to a plea agreement, Your Honor. Well, it's not a plea agreement. It will be another open plea. Uh, 21st.
Thank you.
No, I believe that they want the individuals.
Does the state have an offer on the table?
Your Honor, Mr. Taylor also has suspended sentences of 5 years.
May I approach, Your Honor?
You may. Okay, Mr. Taylor, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So your attorney announced the plea to the bench, and I see you've signed the plea agreement that says that. Have you gone over this plea agreement with your attorney to make sure you understand kind of what the legal ramifications of this plea agreement is?
Yes, sir.
Because you're admitting the violation. We're going right to sentencing. You understand that? Pause. That's not good. Okay. Let me say that again. You understand you're admitting this violation. That's what you're saying. You seem like you're pausing on that.
Yes, sir.
Okay, so you need to talk to your attorney some more, and I'm not going to accept that plea agreement. Maybe later. You go talk to him, and maybe we can come back, bring him back after lunch or something if you talk with him. Okay. Anthony Vila.
You need to come back. Anthony Vila.
Anthony V. Counsel?
Yes, Your Honor. This is Mr. Anthony Vila, Ryan Morrow for Mr. Vila. This is 21 CF 1649 Alpha. We're going to be entering a negotiated plea that contemplates revocation and termination of the probation, 1129 in the county jail with credit for time served, $100 VOP fee, $150 cost of defense, 60 days to pay, and then shall reduce to a lien. May I approach, Your Honor?
You may. Is the state in agreement with that?
Yes, Your Honor. I have a score sheet for you as well. Mr. Vila scores 13.35 months DOC. This is a downward departure based upon which event unenforced plea bargain.
Mr. Vila, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you've signed. Have you gone over this agreement in detail with your attorney, make sure you had all your legal questions answered about this plea agreement?
Yes, sir.
You understand that by entering into this plea agreement, this will be a final resolution of this violation of probation charge, and that you're not going to, have the right to go to a final hearing or even, in most cases, appeal it. Do you understand that?
Yes, Your Honor.
You believe this is in your best interest to enter into this plea agreement, and you're entering into it freely and voluntarily?
Yes.
Very good. Based upon that testimony, the court will revoke and terminate your probation, so you're finished with that. Sentence you to 1129 in the county jail. You will get credit for all time served. There are fees and costs, which you'll have 60 days to pay, and it'll be reduced to a week. If you have a question, talk to your attorney if you have one.
Sorry about that, Your Honor. Please proceed.
Okay. Any further questions do you have of the court or of your attorney?
No, sir.
Okay. Thank you very much.
Michael Acosta.
Here too. What's this? Your Honor, this is Mr. Michael Acosta. Ryan model for Mr. Acosta. It's 21 CF 3252. Your Honor, we're going to be entering a negotiated plea that contemplates revocation and termination of probation, 9 months in the county jail with credit for time served, $100 VOP fee, $150 cost of defense fee, financials to reduce to a lien after 6 months.
Where is this on the docket?
It's number 1. It's my very first client, Your Honor, on the docket.
Michael, A-C-O-S-T-A.
Right.
I show him on page 14, number 28, for the docket that I have. It's right above William Burrell and below Erica Corti. You said that you had found Erica Corti?
Yeah.
It's right below her.
had the case since it's been a court date.
Just give me the case number again slowly.
Your Honor, that's 21 CF 3252.
And how do you spell the last name?
Acosta, A-C-O-S-T-A. First name Michael, Your Honor.
Okay, go ahead.
And we'll be entering a negotiated plea on the VOP, entering admission. The agreement contemplates that the court will revoke, terminate the probation, and sentence Mr. Acosta to 9 months in the county jail with credit for time served, $100 VOP fee, $150 cost of defense, financials to reduce to a lien after 6 months, Your Honor. May I approach?
You may. Thank you. Mr. Acosta, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You gotta put the stuff on you that I can read, counsel.
I'm sorry, Your Honor.
You can't
I know my
scratch it in
handwriting's
here
bad,
where I
and that's
can't
why
read.
I announced it
Okay.
first. I'll do better, or I'll type it up.
That would be better.
Mr. Gates has educated me this morning that we have a recently installed printer over on the second floor, so we'll get right, Your Honor.
Okay. So, Mr. Costa, I see that you have signed the written plea and sentencing agreement that tracks what your attorney just stated verbally. Is that your understanding of what the plea agreement is?
Yes, sir.
And you understand that by entering this plea agreement here today, that you're waiving the right to go to a trial, and this will be a final resolution of this violation of probation.
Yes, sir.
And you're giving up some, valuable legal rights. You've gone over this, made sure you had all your legal questions answered about this plea agreement with your attorney.
Yes, sir.
You believe this is in your best interest to enter into this plea agreement?
Yes, sir.
I said, do you believe that this is in your best interest
Yes, I
to
do.
enter into this plea agreement? Nobody coerced you or promised you anything to get you to enter into the plea agreement?
No, sir.
Okay. Based upon that testimony, the court will accept your plea. The court will revoke and terminate probation, sentence you to 9 months in the county jail. You will get credit for all time served. The fees and costs, you'll have 6 months after you get out to pay them. After that, it goes to collection.
Yes, sir.
Okay? Any questions?
No, sir.
Good luck.
Thank you.
Your Honor, Dr. Walton.
Christopher Cluster.
Your Honor, as to Mr. Acosta, I'm making friends. I'm so sorry. No.
He's 2:30.
Your Honor, I will say I looked at Mr. Acosta's case. He had court on January 17th, and the clerk's minute sheet clearly indicates February the 21st was his next court date.
And he's on the docket that I sent out yesterday.
He's on my docket.
Mr. Medina just signed.
It's all right.
Sorry, Your Honor, we're trying to efficiently manage the afternoon calendar. I'm here with Christopher Daniel Lee Lester in 22 CF 2679. Your Honor, Mr. Cluster also has a misdemeanor case, and the state is willing, if the court will permit, to do a plea and sentence agreement that also deals with that misdemeanor case. May I state the number of that case?
You may.
22 MM 4523 would be resolved as part of this plea and sentence agreement, as well as 22 CF 2679. 22 MM 4523, and I've written it on the agreement. It has 2 counts. Count 1 is a misdemeanor trespass, first degree misdemeanor. Count 2 is a first degree misdemeanor resisting without violence. I've discussed those cases with him. He wants to, in his own best interest, according to his assessment of the situation, enter the agreement to resolve those cases too. Even though I don't represent him in those cases, haven't given him any legal advice, he wants to resolve them today as well. May I approach with the signed copy, Your Honor. It's all a misdemeanor, so there's no score sheet.
Thank you.
Thank you. Your Honor, under the agreement in the 22 CF 2679 case, the state is, and this is Ms. Vasso's prosecution, Your Honor, she's agreeing to dismiss count 1, which was a child abuse charge, in exchange for the following: adjudication of guilt to lesser included offense, simple battery, that's a first degree misdemeanor. The section of the Florida statutes is 784.031B, that's stated in the agreement, and that's on count 2. There will be 11 months, 29 days probation, anger management class, no contact with J.O.G., date of birth, September 10, 2005. I wasn't sure what the court costs were for that kind of a case, so Madam Clerk could let us know. It's 150 PD fees, and he may perform community service for eligible costs. If you want to get your court costs down, probation may allow you to do some community service for some of that. But there's some that you're not allowed to do. Supervision would be by JCS. And on the misdemeanor case, 22 MM 4523, the 2 misdemeanors, trespass and resisting without violence, that's with an asterisk. Thank you, we got cards for JCS. Adjudication of guilt as charged in 22 MM 4523, time served, court cost, $50 PD fees.
State?
That is the state's agreement, Your Honor. I'm also in agreement with doing the misdemeanor case.
Mr. Cluster, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you signed. Is that your understanding of what the plea agreement is, you're in agreement with?
Yes, sir.
Okay. And you understand by entering this plea agreement, you're waiving the right to go to a trial and giving up some other rights, right to confront witnesses, etc. All to have a final resolution of this matter. So be a final resolution. Do you understand that?
Yes, sir.
Have you been able to speak with your attorney in detail about this and make sure you had all your legal questions answered regarding the effect of this plea agreement?
Yes, sir.
And you're entering this freely and voluntarily?
Yes, sir.
Nobody threatened you or promised you anything to get you to enter into this plea?
No, sir.
Okay. Based upon that testimony, the court will accept your plea. And the court will accept the state's dismissal of count 1. And as to count 2, there'll be a lesser included charge of simple battery, in which you will receive and be sentenced to 11 months, 29 days probation. As a condition of that probation, you've got to attend and complete anger management class. You'll have no contact with JOG, with the date of birth that's contained in here. There's fees and costs. You will have supervision by JCS, and as stated by your attorney, the misdemeanor charges, you'll be adjudicated guilty, and you'll get credit for time served, and then there's court costs and fees in there. Those are all payable during the term of your probation. Okay?
Yes, sir.
Question?
No, sir.
Thank you very much.
Edward Colley.
Your Honor, Edward D. Cawley is before the court in 22 CF 3029. Yeah, we have an agreement resolving this case, 22 CF 3029, and he needs to sign the agreement, which we've been over, Your Honor. That's what. May I approach, Your Honor, with the agreement? I've just got to make a picture of it so I can read from it. That'll be only the score sheet. Yes, ma'am, call it. May I approach you? Sorry. Thank you.
Go ahead.
Your Honor, under this agreement, the second-degree felony that Mr. Cawley's charged with will be an adjudication of guilt as charged. There will be 3 years probation with a special condition of bars to bed Haven House. Your Honor, Haven House is in, I believe it's in Santa Rosa County. Santa Rosa, is that Santa Rosa County? Okay. It's $615 in court costs, $150 public defender fees. And I think that basically probation would need to come and meet with you before you get out of jail. And you'll have to report when you finish Haven House to probation as well in Okaloosa County. You understand?
Yep.
Thank you, Your Honor. They've got a bed ready for him at Haven House, Your Honor.
Very good. State in agreement?
Yes, Your Honor. And just for the, I don't have a score sheet printed out, but I will print that out and we can submit it to the court this afternoon. Mr. Cawley's total sentence points are 56.2, just for the court's information. This is not going to be a downward departure, but it's based on a negotiated plea.
And I would note, Your Honor, also is that Ms. Sharpless informed me that she and the victim agreed that he should have a shot at treatment, so I know he does appreciate the victim's willingness to allow him to get help with his disease, Your Honor.
That is true, Your Honor, and I don't believe, just also for the court's information, this is also part of an agreement because he has no prior offenses.
Mr. Cawley, would you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney, put your hand. You heard your attorney state the terms of your plea agreement. It's also contained in this written plea agreement that you've signed.
Yes, sir.
Have you gone over this in detail with your attorney to make sure you understand all the legal ramifications, make sure you have all your legal questions answered?
Yes, sir.
Understand that by entering into this plea agreement, there will be a final resolution of this violation of probation, and you're waiving the right to go to a trial to contest all that.
Yes, sir.
You believe this is in your best interest?
Yes, sir.
Well, I certainly hope that it is positive, and that is a good program at Haven House, and I hope that it works well for you. The court will accept your plea agreement as stated. There'll be an adjudication of guilt as charged, and you will be sentenced to 3 years of probation with a special condition of bars to bed to Haven House. Fees and costs are payable during the term of the probation. Thank you, sir. Good luck, sir.
Right this way, Mr. Cawley.
Good luck.
Your Honor, the three that we, Mr. Cawley, the three that we still have back there that you wanted brought back at the end, are we ready for any of them?
Let me ask you one question. I've got a Corey Kromchak, Mr. Medina, non-inmate.
Your Honor?
Corey Kromchak.
Yes, he is, that's the gentleman who's in federal custody. I think the state might be prepared to dismiss that. Do you have assurances?
Your Honor, this morning an old cross was entered.
Okay, very good.
He's been sentenced in federal court.
Thank you. Got that.
It was filed this morning, ma'am.
Thank you.
So, let's see, which ones do we have back there?
I believe we have Malone, Taylor, and Castillo.
And those are all mine, Your Honor. I still needed to confer with Mr. Taylor to figure out what the hitch and the giddy-up is. The state has requested some information from Mr. Castillo that I would need a moment to confer with him to get, and then Mr. Malone is reading over his paperwork that Mr. Gates provided.
Okay.
Can we approach on Mr. Castillo just briefly?
Sure. I don't know what to do about Sheldon because we don't have an attorney, and I'm not gonna do a Feretta without at least having the attorney here. There's a substitution, I'm confused about that. Shelton?
I do, Your Honor. I'm texting my.
And I've got a substitution by Benjamin Buck.
I'll be honest, Judge, he just got on the case.
Right.
And I can't represent to the court that he even got the order because I haven't had any contact with him. I have no idea if he knows he's appointed to Mr. Shelton. It may have been Easter on him, but I don't.
It was sent on February 17th to Mr. Benjamin Buck. The order that you signed, Your Honor, on 2/16 was sent to Mr. Buck on 2/17.
Email.
You signed the order and you filed out to ben@benbuck.law.
Where's that book?
Tallahassee, I believe, It wasn't Tallahassee.
He's in
You think you might be trying to reach him soon?
I don't know why.
Yeah.
And Your Honor.
We didn't send out a Zoom link, so.
He's on your general list because you've used up everyone on your restricted list, so we had to give him to Buck. He's on your general list.
And Your Honor, if I may.
Sure.
Be in front of the court at this time.
It would be much appreciated.
Mr. Buck, I believe, is no longer living in the state. He's currently being disciplined by the Florida Bar for closing his practice without notice to the courts. So I wanted to make sure the court is aware of that if he's appointed.
The court was not aware of that.
Yes.
I
so
was
that-
not aware of that either,
Article, and
Judge,
I
so
thought
I
the name
appreciate.
sounded familiar, but I read that article.
His discipline is currently pending.
So
before
I
the
appreciate
Florida
Ms.
Bar.
Sandler's amicus situation at this point, because I did not know that either, Judge.
This list is decided in Pensacola.
I'm sorry?
In Sandy County. The list says administration, and it used to be carried.
Yeah.
They would need to be notified. They're in charge of the list that we actually appoint off of for you. So court admin in Sandy County needs to be made aware somehow.
I will do that. We gotta figure out what to do with Mr. Sheldon. Let's get him. Why don't we, continue this case to 3/21? And I'm going to double back and make some contact regarding appointment of counsel. And the only thing that we have even on there is the Feretta motion, which I don't know whether he still wants to pursue his, what does he have outstanding at this point? Is there a motion, is there a violation of probation?
Your Honor, I think these are two new cases.
These are two new cases? Okay, and we will.
He does have two new cases.
For two new cases, both of them are drug possessions.
I'm sorry?
Both of them are drug possessions.
Right. Okay, so we'll continue that to 3/21.
Ms. Sharpless and Mr. Medina, if I could just get clarity on Edward Cawley. He was an add-on for today. Judge has sentenced him, but what we have on file is a first-degree robbery. But the information that was filed looks like a second-degree felony, whereas it was filed under a first-degree felony.
So the information controls.
I just tapped in the 8121332B and it brought up an attempted robbery. Is that okay?
It's attempted 812.1332B.
Yes, sir.
The state has said was attempted carjacking without a weapon. What is and that's what I wrote, I think.
And Ms. Maupin, it went down to a second-degree felony because it's an attempt.
Excellent.
That's why, it doesn't change the
I
level.
just put it in our system, that way I just wanted to make sure, I didn't hear Tim.
It's okay.
Yes, ma'am.
It doesn't change the level, but the degree changes because of the attempt.
Thank you.
And we did write it like it is in the information tab. Thank you. Thank you.
No.
Good.
You can bring him up to the podium, Mr. Morrow.
Certainly are. I just didn't want to mess up his signature. Brian Morrow for Mr. Malone, Your Honor. This is 19 CF 648 Alpha. This is going to be a plea to the bench. We've prepared some paperwork. And Mr. Malone would like to offer some mitigation explanation of the court before the court imposes sentence. May I approach?
Okay. You want me to sentence today?
We can in this matter, Your Honor. That would be fine.
Is the state prepared?
Yes, Your Honor, that's fine. I've got a score sheet for Your Honor. Which one will show this tomorrow first?
Thank you.
May I have a picture, Your Honor?
You may.
Good. Both of them to March 21st.
Okay, Mr. Malone, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so I see your attorney just stated you're entering a plea to the bench, and the same thing is contained in the written plea agreement that you signed. You've gone over it with your attorney, I assume?
Yes, sir.
Do you understand what the maximum sentence that could be given by the court?
Yes, sir.
How much?
5 years.
Okay. You understand that by entering this plea agreement, the first part of it, the process, in other words, you're admitting the violation, and we're going straight to sentencing. You understand that? And this will be a final adjudication of your case. Is that what you want to do here today? Okay. Based upon that, the court will accept your plea.
May I take some testimony from Mr. Malone, Your Honor?
Sure. Under oath, you may continue.
Okay.
Mr. Malone, you're here before the court to admit this VOP, yes?
Yes, sir.
Can you tell the court a little bit about how your life circumstances have changed since you were initially placed on probation?
Yes, I can. Would I you want to explain it?
Please do.
Well, when I did violate, I was struggling then, and I didn't have no stability, no job, and so I couldn't pay and like that. But now I have a stable job, I have a stable living situation. I can pay even earlier. I won't need probably like 90 days to pay all my fees. And well, I'm pretty much stable now. If you give me another shot to redeem myself.
Is there anything else you would have the court know before they impose sentence?
Take a suspended sentence if you want, Add another year, take a suspended sentence, I'm trying to do it over new right this time, So.
And you're confident that if the court was to see right to modify or reinstate your probation, you'll be at liberty,
100%.
you will be able to finish these conditions?
100%.
Understood. Nothing further from me, Your Honor.
Mr. Rogers?
Your Honor, the case at issue before the court related to Mr. Malone apparently arranging with the victim in the case to sell his vehicle. Mr. Malone accepted $1,000 from the victim and a vehicle was never conveyed. This is Mr. Malone's first felony. However, I think the court should note that Mr. Malone was sentenced in this case in June of 2019, placed on probation at that time. The report filed by probation indicates that Mr. Malone failed to report in November, and this is the first time, apparently, that Mr. Malone has interacted with the courts since that occurred. So we're looking at a period about 3.5 years since Mr. Malone has essentially been in the wind, absconded. Based upon that fact alone, I'm asking the court not re-sentence Mr. Malone to a period of supervision and essentially waste probation's time and the court's time considering his performance before. Based on that, the remaining option for the court is incarceration. I'm asking that the court impose a sentence of 1129 Okaloosa County Jail. Just briefly, if the court is interested in Mr. Malone's criminal history, it is laid out on the score sheet. I'm seeing 6 prior misdemeanors.
You seeing what?
6 prior misdemeanors, Your Honor.
And I'll make argument whenever the court's ready, Your Honor. I just didn't want to interrupt you from researching. Understood. Your Honor, Mr. Malone was given the benefit of a withhold adjudication on the underlying case, and that's the reason for the request from the defense that he be reinstated or modify the probation to some greater form of supervision and allow to finish him out. He's asserted to me that he is a candidate for supervision. I'm not defending the absconding or the failure to report. I'm not here for that, Your Honor. We're just asking the court, now that his life circumstances have drastically changed since he was initially placed on probation, that the court be willing to give him another chance so he can earn that withhold that he was given on the front end, Your Honor. And that's what the defense is asking for today. If the court's not inclined to put him back on supervision, we would ask that the court sentence him to county jail, the court's discretion, and not state prison. He's sitting on about 17 points. I don't feel as though prison sentence is appropriate in this case.
Well, first of all, it's not an insignificant charge. You've had prior misdemeanors. You understand there's a difference when you move to a felony charge, and quite frankly, no matter your circumstances, absconding is kind of flying in the face of all that we try to do. Probation is essentially an accommodation. It's an alternative for somebody to, it's an alternative to incarceration, to give you a chance. And to abscond and just walk away from it for a number of years doesn't work. So the court's not going to reimpose probation. The court's going to sentence you to 1129 in the county jail. You'll get credit for all time served during that period. Okay?
Your Honor, to the extent it needs to be said, the state would ask that any pending restitution costs be converted to collections.
Correct.
We can't do restitution, we'll need to file a civil lien for that, just.
Understood.
Okay.
Okay.
That's right, Mr. Mullen.
Your Honor, probation is terminated.
Yes, probation is terminated.
And there was a previous withhold, it's now an adjudication.
That is correct. Thank you.
Your Honor, if the court would excuse me for a moment, I'll go out and talk to Mr. Taylor and see if we can figure out what's going on. Or
He's in the feed, do it right there.
You want to just take him first up at 1:30 when we come back?
I can do that, Your Honor.
Why don't we do that? Everyone else is waiting around. It's noon. Come back at 1:30 and we'll deal with that first.
You got it.
Yeah.